Good evening, everyone. Um, uh, it's a real privilege for me to welcome all of you to the launch of a new talk series and to what promises to be a particularly important and exciting discussion. For those of you who don't know me, the president of the Center for Policy Research. And today we are launching the first in what I hope to be a long term series titled Talking Rights Seriously. The idea behind this series, it actually came to us largely because we realized that within the building in the Center for Policy Research, we have far more lawyers than we have trained public policy experts. Says something about the state of our higher education and also says a lot about the interface between law and public policy. Increasingly so in India, as the courts have begun to play a particularly proactive role in protecting, shaping socioeconomic rights of citizens. The relationship that law now has with almost the everyday of public policy, whether it is the right to work, the right to information, the right to food, and even in the context of the discussion we're going to have today on Aadhaar and privacy, the law is playing a very central role in shaping the contours of public policy and shaping the direction in which different arms of the state are moving as they aim to deliver and protect socioeconomic rights of India's citizens. With this background, we felt that as an institution that deals with the everyday of public policy, with many lawyers engaged in these questions, it would be very important for us to begin a line of inquiry that starts looking at the nature of jurisprudence that is emerging from courts, especially in areas that intersect with socioeconomic rights. We felt that there are two very important things that we need to understand. One is to question and deepen our understanding of the precise nature of the role of the courts in and of itself. There are very important positive interventions that the courts have made. In fact, in my own area of research, which is in the space of accountability and social policy, the role of the courts has been quite central in ensuring that very, very critical social policy programs are being implemented. So much so that many political scientists have commented that the executive almost only responds when the courts start intervening. And therefore, in many ways, the courts have played a very positive role in shaping social policy over the last decade or so, but it also raises very important questions about the limits of the court and the consequences of the courts playing such an interventionist role, often in areas which may not necessarily be the prime area of expertise of the courts in itself. This is a question that often comes up when we talk about the role of the courts in protecting socioeconomic rights, but one that I think requires a continual and fairly serious engagement. In today's conversation, we hope to have a fairly detailed discussion on the Aadhaar judgment, which has many different intersections with aspects of public policy, both in terms of the shaping the legal regime around the increased use of technology in public policy, questions around how one should legislate and regulate the role of technology, but also questions around how technology and welfare intersect and how the law begins to frame that. So it's a real privilege for us to have together today such an exciting panel. All of our panelists have been in different ways engaged in the Aadhaar judgment, and we hope to get a fairly robust understanding of the implications of the judgment, the rationale behind the judgment, and also perhaps a little bit of a conversation going on what this means going forward. I'd like to invite my colleague Anand Padmanabhan, who's leading this discussion today, to carry the proceedings forward. Thank you, Anand.
Thanks, Yamini, for that wonderful introduction to the series and how we are thinking about rights. So I think being someone who grew up on the Mahabharata, the way I look at this particular panel discussion today is that the time after the battle is a good enough time, or as good as any other time, probably a better time to reflect on where we are going after these huge battles. The Aadhaar hearing, as all of us know, is the second longest hearing in the history of the Supreme Court. Went on for I think about 34, 35 days, right? And the interesting context is that just about a year or a little more than a year ago, the Supreme Court had conclusively finally made it clear that the right to privacy is a part of fundamental rights in Puttaswamy 1 in 2017. And interestingly, rooted the right within the idea of human dignity and the right to life, and Article 21. But then, what does it really mean by way of practical application? And that's what the Aadhaar verdict is really all about. It's the first test case in what I am sure is one among many more to come, to think seriously about the relationship between technology and rights, the relationship between efficiency, the various welfare trade-offs, and fundamental rights, and most importantly, the very content of informational privacy itself. What does it mean when we say that our personal data is sacrosanct, and there is a relationship that we share with the state when it comes to our personal data, and there are lines that the state cannot cross. So today we are really here to start looking at what jurisprudentially emerges from this particular verdict, both in terms of what it means for the Aadhaar project and in terms of what it means for personal data protection more largely. So with that brief introduction, let me just call upon our panelists. First up is Ms. Meenakshi Arora, Senior Advocate, Supreme Court of India. So ma'am has argued for the petitioners in the Aadhaar litigation. Then we have Vrinda Bhandari, Advocate, Supreme Court of India. Again, someone who has written extensively on privacy in India and has assisted counsel appearing in the matter. Next up, we have Dr. Orgo Sengupta, Research Director, Vidhi Center for Legal Policy. Orgo has been involved with the drafting of the Aadhaar Act and in the litigation to deal with the right to privacy, the Puttaswamy 2017 verdict. And finally, you have Mr. Zohaib Hussain, again Advocate, Supreme Court of India, who's appeared for the UIDAI and looking at the Aadhaar Act from that perspective. But going beyond the individual subject positions that each of them have held, they've all been gracious enough to look at the wider context in which Aadhaar has evolved. So the way we have structured this discussion is that we'll have a set of opening remarks from each panelist on themes that we have sort of identified, and then it's followed by a conversation between all of them and me, and finally we have Q&A for about 15 to 20 minutes. Thank you all for taking a Friday evening out, which I know is the line that one doesn't generally cross with lawyers, because that's the only time you really get off, practicing lawyers particularly. So Vrinda, I'll begin with you. Since you're someone who has been looking at privacy for a long time, right? I mean, apart from your involvement with the Aadhaar litigation, to look at how the concept of privacy has evolved. So 1 year ago, we had Puttaswamy, which basically said this is part of your right to life, and then leaving it to the next constitution bench to flesh out what the right means in a real sense. So now we have the verdict. So to you, what are the privacy harms that have found acceptance categorically, both in the majority and the dissenting verdicts? Right? I mean, there is a majority which is 3 judges. There's a concurring view, and then there is a dissent, a powerful dissent by Justice Chandrachud. And the interesting thing about dissents is that many years ago, as we know, the right to privacy itself was an uncertain right. But then there were few dissents that were powerful enough, and which now has become the law of the land, right? So to you, what are the different harms that have been identified in the verdict? And if you look at the verdict itself, are you happy with the way the majority has, for instance, brought in some safeguards like data minimization, purpose minimization? For instance, reading down section 7 of the Aadhaar Act, which said you could use Aadhaar for all kinds of welfare schemes and so on, but then limiting that. So to you, where does all this tie in with the idea of privacy itself in India, and how do courts, how do our judges look at it in this particular case?
Thanks. So I think both the majority and the dissent sort of agreed on the initial framing of what the rights that emerged from Puttaswamy 1 were, which was, talking about bodily privacy, which is the idea of, privacy in terms of space. Then there's informational privacy, which is privacy in terms of, your mind and and then the third is decisional autonomy. So that's the right to choice. They also understood that privacy can be understood in the context of harms and interests. I think where the majority and the dissent sort of fundamentally differ, because they agree on all of these interpretations of Puttaswamy, is in their framing of the rights. So Justice Sikri, who wrote for the majority, essentially sets up the entire Aadhaar debate as a debate between the right to privacy versus the right to food. So in the context of Section 7, is it that is the right to privacy so important, or can it be sacrificed if it ensures that the right to food is guaranteed, because the government can give these safeguards and can ensure that food is targeted and the benefits are targeted to the people. So that's the essential framing with which Justice Sikri proceeds, that it is one or the other in some sense. And Justice Chandrachud actually dissents on this point, saying it doesn't have to be mutually exclusive. The government has to show me that there is no way in which both the rights could have worked together, and it was not a case of one versus the other. The second thing, and this also the second place where they distinguish, where they differ, is on the premise. So for Justice Sikri, the uniqueness of the biometric project is actually one of the best things about UIDI, about Aadhaar, and he believes that there are not really, there is no reasonable expectation of privacy that is violated in this case, because there is no possibility of misuse. So he pitches the case very, very high, which is that Aadhaar there can never be any duplication, there can never be any misuse, there's no possibility of surveillance. So he pitches the case very high and hence says there's not really a privacy violation that deserves our intervention. With Justice Chandrachud actually recognizes what are the possible privacy harms. So he talks about, when you have a biometric project that's this large, you have the possibility of profiling, you have the possibility of discrimination. How does it affect the poor people in particular versus the rich? And there is a sort of difference in context. And this brings to another third area of disagreement, which is the role of individuals. So privacy is generally understood, when you give autonomy and consent centrality, you give the individual as a being centrality. Justice Sikri sort of, when he dignity, and he talks about dignity a lot. So actually, if you read parts of the majority judgment, you think it's going to reach a different conclusion because of the focus on dignity and choice and all of these things. But then he comes up with this idea of sort of a community dignity and this humanistic idea of public good. And he also, in some ways, sets up a clash between the individual and the public good as well. Whereas for Justice Chandrachud, like, the individual is the soul of the judgment. And he gives a very interesting example that really struck out when I was reading his dissent. So he talks about the fact that there was this Biometric Standing Committee report in 2010. This is, when they were coming up with all these proof of concept studies that had collected the fingerprints of 25,000 people. So that was 2.5 lakh fingerprints. And he says, it's not clear what was the basis of consent for getting these fingerprints, what were these people told when their fingerprint was being collected, and most probably these are poor people. And if you think about it, if the government came to us and said, oh, give your fingerprints for some, proof of concept study, we would probably oppose it. And so I think this idea of how it affects the rich and the poor and what consent means, I think like this example really stood out to me. And when you talk about privacy harms and the stages at which the harms can be, I think it's easy for me if I think about it in terms of collection, storage, and use as the three stages where different harms can occur. And this is how we'd also tried to pitch our case in court. And when he talks about, when you talk about collection, Justice Sikri and the majority essentially proceeds on the premise that minimum biometric information is collected. So it's only as little as possible. So the fact that fingerprints and iris scans are collected is just the absolute minimum. That they've not done more. They've not collected DNA, for instance, which I think is interesting because he does not engage with the fact that the act actually envisages, there's this definition of biometric and core biometric says, and other biological attributes. And this was one of the arguments that, tomorrow it can be DNA or it can be any other thing. And, some of the counsels who were appearing, Mr. Rakesh Dwivedi also said that, okay, actually DNA would not be there. You don't have to interpret it as including DNA. But none of this discussion finds a part in the judgment itself. And Justice Sikri also proceeds on the presumption that this collection of information at this large scale is okay because there are procedural safeguards. And then he relies on this, the PowerPoint, the infamous PowerPoint, and says that, oh, there are all these safeguards, and because this is there, there's really no concern. And I think there are two other interesting points just on collection. So it was not our case that the collection of biometric information per se is wrong, because obviously you do it when you talk about, when we give it for passports, it's collected in many criminal contexts when you talk about the Identification of Prisoners Act, in the Census Act. The argument was it's a large scale collection without any basis. Like everyone is under this net. It changes the idea of presumption of innocence, and there are no safeguards. And when you talk about it in the context of passport, the information is siloed. What happens with Aadhaar is that these silos sort of end up merging together, and that is the problem. And he doesn't really engage with this argument. He gives this example of airport and surveillance, and he says that the point of entry of an airport may be known and the point of exit another airport, but you don't know which flight the person is going on, which sort of then talks about metadata, and I think ma'am will talk about that a bit more. In the context of surveillance. The second idea, and just in terms of storage, and I think that goes to your question of some of the safeguards. So that's where some of the safeguards have come in, where they've said, 5 years is too long, data shouldn't be stored for 5 years, and that's unconstitutional. And I think the other interesting thing here is Justice Chandrachud talking about how it's not just the security of the server itself, but also how it can be used unauthorizedly by third parties. So you have to also talk about sort of the knock-on effects. And I think the last, and maybe we'll come to proportionality later, so I won't touch upon that right now, but is this whole idea of the probabilistic nature of biometrics. And that, again, I think talks about your view on privacy and the harms, is whether biometrics, by their very nature, can be fallible. Are they probabilistic? Will they always work? We're obviously living in a country where you have, a large rural population, a large manual labor population, old people, and even notwithstanding all of that, even for people like you and me, biometrics can fail. That's just the nature of, the probabilistic nature of biometrics. And I think we'll later deal with Section 7 and the safeguards, because I think there the judgment truly missed out, and I think this is it's a real loss. I mean, obviously, the idea of private parties and Section 54 and some of the other safeguards are very good, but I think Section 7 is the fact that it's really not been narrowed to the extent it should have, and there's not been an engagement with the data, with the idea that there was exclusion. And I think Zoe will maybe be talking about that, so I'll come back to it. But I think those are issues, for me, that's the biggest issue with the judgment, is how it deals with Section 7, how it deals with exclusion, how it really doesn't deal with any of it. It just says, oh, these are disputed questions of fact. So you have, the judges relying on this, like the PPT as sort of fact, but when we came up with all of these affidavits and all of, these studies, none of them are even mentioned. Even if they had to be distinguished, it should have at least found, a reasoned part of the judgment.
Ms. Arora, turning to you, I think the framing itself from Puttaswamy 1, the 2017 verdict, was that the violation has to be, or the law has to be, decided on the basis of the triple test. So by framing this triple test itself, in some ways you are leaving out questions of policy, and to me exclusion looks at some level a question of policy as much as one of principle. But just to go revisit the triple test again, the court basically held that you need a law, you need a legitimate state aim, and you need a reasonableness standard, and for the law to meet that standard. So now, particularly when you look at the various kinds of harms, the one that stands out most significantly and most worrisome, in a most worrisome sort of fashion, is the surveillance aspect. I mean, it's a little Black Mirror-esque, right? I'm talking about this one number which is seeded into multiple welfare programs. I mean, I don't know the final count, but I guess currently about 150 odd programs, and on top of it, at that point, there was private authentication, which of course now the court has struck down. But my point being that there was this huge expansion of seeding, which allows at some level for the state or various state entities to find an individual and profile an individual better. So it's a distinct kind of privacy harm among the multiple kinds of harms. So I'd like you to sort of enlighten us on, one, the proportionality standard itself and the way the court has applied the triple test, and particularly in the context of digital surveillance, and what does it really mean for the future of surveillance, the verdict and the leeway that it gives to the state.
Thank you. But if I may put it in my own way.
Sure.
Okay. When the Aadhaar fight started, this was 2013, and we had some foggy ideas on how Aadhaar was really not the right thing that was happening. Mind you, the legislation came much later. So when the Aadhaar thing started, the first thing that struck me amongst my other colleagues was that here is a government that's collecting all this data without any consent, which includes your biometrics, all your details, and it's being said it's you have to do it, you have to go and get it, and people just it's your identification. So it was happening in the beginning, if you all would recollect, that we were all pushed to these centers to say, this is going to be now your identification, and this, the previous identifications like your election cards, your ration cards, etc., are no longer, but this is going to be your new identification. It was unfortunate, most of our population, which was not well informed, or poor people more particularly, thought they must go and get it. This is like the government's giving it out, we have to do it. The other thing that really struck us was, as we went along, somewhere a little bit ahead after 2013, maybe around in 14-15, the government collected this entire database at a huge cost to a taxpayer. And the database was now put and was going to be used, so for the purpose of authentication, which is going to be done by the banks, by the mobile operators, by so and so, by so and so, through a private agency, which would be charged, maybe a small, whatever be the fee, for giving this authentication. So this kind of, I will be honest, bothered me immensely to get more and more involved into the matter as to why something that is being collected at the taxpayers' money, now data is the present oil. You know what oil was few years ago, it is today the same value, it's the today's gold, black gold, it's the data. So this data is now going to be used by the private entities to run their business, which they get virtually on a platter, collected at the cost of a taxpayer. Then comes a third thing that kind of just sent the alarm bells ringing for us, which was around 2015, if I'm not mistaken, when the government came up to the court and said that we as Indian citizens have no fundamental right of privacy. Now, I thought that was the deepest pitch in this whole fight against Aadhaar. I mean, if after almost 70 years of our independence, we are to say that as citizens of this country, we do not have a fundamental right of privacy, where is then Aadhaar headed to? So we went through the first battle, that was Puttaswamy, to first establish before a 9-judge bench of the Supreme Court to say we have the fundamental right of privacy. But you must not forget these factual backgrounds before you come to the validity of the Aadhaar test and how you take it forward. So the Supreme Court held that yes, we do have the fundamental right of privacy. Now this right of privacy includes all the various factors it takes into account. I would now concentrate, when I talk about privacy, onto the aspect that Aadhaar, in its form as conceived, would become virtually a tool for surveillance. In fact, mass surveillance, or may I call it more a control over the population, making us virtually a very docile population. And why do I say that? Aadhaar was something from cradle to the grave, which was at the time of the birth, you get the Aadhaar. When you go to school, you are one number. Now let's come to that a little bit later. Aadhaar meant you are one digit, multiple digits, you are one number, which is supposed to be now your identity. So an individual, as a human being, as an individual, I got subsumed into this one number, which I would carry from my cradle to the point of my grave. For everything that I did, from the time that I am born, to my school, to my getting out, to my car, to my property, to my income tax, to my mobile phone, to my whatever that I do, it was Aadhaar. It became so much so that it was said that next time that you take a flight, for an entry into the airport, you would show an Aadhaar card, and when you exit from the airport, you would show an Aadhaar card. Now remember this. I'm going to take it a little bit further. When you had the emergency, they were able to fight back the emergency. How did they fight the emergency at that point in time? That's because they were collectively able to assemble at various places. They had a sense of security. They could operate their bank accounts and they could draw their money. They could come together in secrecy to be a movement against that authoritarian regime. But now put yourself in the present context that you are one multiple digit number which can be tracked in everything that you do, from making your mobile phone call or your phone call to when you sit in your car in the morning, because when you purchase your car, the next thing they ask you is your Aadhaar number, so it's linked to your registration, to the next red light that you cross with a camera where you'll be tracked, to your bank account that you will operate today, to, for that matter, whatever you do till you come back to the privacy of your own home. So that is 24/7. Now it is all very well for the government to say, the data is collected, but it's in individual silos, and they say that it can be used, but it will not be used. That's what they say. Then I ask myself the question, I accepted that the present day government may not use it. The present regime may not use it. But can I have a crystal gazing glass into my future to say that I will not have a regime anytime in the future which may want to misuse this whole thing? So now the proportionality. Would you then create something that is capable of such an intrusion? It's capable into your own private lives, which can be misused. Is the proportionality of that enough to the use that you say? Now let us consider what are the uses. Do I have 2 minutes more to finish it? What are the so-called excellent uses that the government propounds? Aadhaar has. Government says we reach out on subsidies, on rations, on other benefits like your gas, etc., to the poorest of poor, and we try to avoid a leakage of that, number one. Number two, it says we will try to tap those who are tax evaders or other people engaged in economic offenses activities. Number three, they talk about the security. Let us now talk about the rations. Your right to an access to food is a fundamental right. Your right to access to education is a fundamental right. Aadhaar is virtually a license or a prerequisite to access that fundamental right. If somebody very poor cannot get an Aadhaar, will not get the ration. Of course, the Supreme Court held in a judgment subsequently that even they shall be entitled and get it, but originally Aadhaar as envisaged, you will show a license. Your access to a fundamental right is now, license is a precondition to access your very fundamental right. So according to me, that was completely a no-no. Number two, we have actually today in the present judgment discriminated against the poorest of the poor by holding that yes, for all those who access the government subsidies, who access any kind of a government benefit that comes out of Consolidated Fund of India, cannot do so without an Aadhaar. It's only because the poor who do not have a voice, who cannot stand up and fight, will today have to have an Aadhaar even to access that basic right to food. That is what the impact is. So far as now the mobile phones, the income tax, yes, it is there, but your bank accounts, everything, the court has taken that away. Coming to the next limb on the proportionality. Would the government be able to say that for our 60, almost 70 years of existence as a country, we have not been able to provide services without this so-called one number? is that proportionality, that to put us all, take away our individuality and make us one number like the Nazis did for the Jews, if I may say so, is the only way out for the government to do these three facets that it so called says, which is the supply of food leakage, evasion of taxes, or for the purpose of security. The security I'm coming to as my third layer. No, we've done it for 70 years and there was no reason. If we had proper governance, we should have been able to tackle any of such evasions or any such leakage. It was only a matter of administration and nothing more. Coming to the security, this aspect on the security has been tested worldwide. Europe has gone through this entire exercise, particularly in terms of data. Very small example, there are 3-4 excellent judgments that came out of European Court of Human Rights, but there is one that really kind of sticks to my mind. In Digital Ireland, there is a law in England that said that if you had been accused of a crime but subsequently you had not been convicted, the data must not be retained, it has to go out because you can't live with the stigma all your life. In England, they didn't do that. They kept the data. The defense that was taken by the government was, we need it for our policing, we need it for our security, because then we are able to track the criminals easily. It was upheld up to the highest court in UK, was carried to the European Court of Human Rights, which said, no, you cannot do this. If it requires the data must be erased, because you can't have a person living with the stigma when the law says that you have to erase that particular data. They said, irrespective of what you say about security, it is not enough a proportionality test to affect a person throughout his life to live with that data behind there. And the last thing, I'm ending it there, Aadhaar would be something like a panopticon. A panopticon which was said years ago by Bentham. He said, put all the prisoners where they will be seen all 24/7, every activity of theirs would be scrutinized. What is the outcome of a panopticon? If you feel at any given time that you are under this constant surveillance, you become docile individuals because you start to behave like that. You will not fight back because you will say, oh my God, I am being always scrutinized. So the idea is to make your population a docile population. This would be the worst thing that you could do, to put them under a complete 360-degree surveillance. I'll deal more as you ask the question. Thank you so much.
Thank you, Ms. Arora. I think that really captures the various harms and the surveillance, aspect particularly from both Brinda and you. Now I'd like to turn to Zoeb. So Zoeb, I think the interesting thing here is that there is a challenge to the act, and then there is a broader attack on the project itself, right? I mean, that's the way at least I saw many of the written submissions and arguments in oral hearings as well. And when you look at the project itself, the question really is that of trade-offs. I mean, while we do concede that privacy is a valuable fundamental right, we also do we are also aware of the existing realities in terms of pilferages at the last mile, and a country that has always had massive challenges, well documented challenges when it comes to delivering goods and services to the right set of beneficiaries without pilferages and those kinds of losses. And moreover, a state where today big data could actually help you develop policy better. I mean, there is a lot of benefits currently which are being researched upon, and which today people are talking about in terms of whether it's disaster relief, whether it's in terms of targeting policies, whether it's actually formulating new policies. Numbers and data can provide a lot of insight. So from what I could see, the case that UIDA had made was basically on two very strong pillars in some sense. One, the numbers when it comes to savings, right? And to say that these are, the huge welfare benefits, and there are these, trade-offs that a society may have to make, and these are the trade-offs, and this is how the law should evolve in terms of proportionality when making the trade-offs. And the second important pillar was thinking about the UIDAI itself. I mean, the PowerPoint presentation, which Vrinda said, the infamous one. In some ways, the PPT also, mentioned a lot about the way UIDAI is handling the data, the way the CIDR stores the data, security standards, protocols, and the overall regulatory framework. So these are two things based on which the court has, while deciding to curb down some of the various ways in which you are using the Aadhaar number, not entirely struck down the project and given a fair degree of leeway. So to you, how do you see this evolve in terms of tomorrow if there is another Aadhaar, right? I mean, how do you use this verdict to say, look, this is where policy questions stop, this is where questions of principle begin, one. Two, this is where, something like chilling effects doctrine, begins, and this is where you cannot strike down something because the mere potential for abuse is not, violative. So how do you see these trade-offs, really play out on the basis of this verdict?
Yeah, thanks, Anand. Firstly, I would like to say that one of our biggest challenge before the Supreme Court was to fight perception. And as a lawyer for the UIDAI, which I'm not today I'm not going to defend UIDAI, I'm just going to analyze the judgment and present it as dispassionately as possible, like we did before the Supreme Court.
Right.
Now,
I can believe that.
you know,
only the PPT may have been a little problematic.
So, yeah, like I said, the battle was of perception. So, what was done was to break down every single part of the process, and which is why the PPT had become so important, right from the process of collection of data to storage to authentication. Every single aspect was broken down into its finest of details and presented before the Supreme Court, and as well as to the Petitioners' Council, so that there is complete clarity on what it is that is being presented and what is it that the entire scope of the project is. Now, as far as your framing the problem is concerned as a trade-off, I personally do not agree that it is a trade-off, or at least the majority has not treated it as a trade-off, even though that is how it is being seen. The court was balancing various interests, and in that process of balancing, it has struck down various provisions which it felt infringes privacy. So the proportionality test is not that, okay, there is a right to food and right of the government to savings and right of various people, so that they cannot be excluded from their right to food on one hand, and on the other hand there is right to privacy, probably of the same person, because it's not different people's rights we are talking about. It's right of the same person that is being weighed against each other, and therefore, okay, these are more important rights, therefore we will let this trump the right to privacy. That's not what the majority has done at all. In fact, the majority has said that privacy as a right has to be safeguarded irrespective of your, and there's Justice Sikri has spent a good amount of time dealing with this concept that just because right to your food is being provided or other fundamental rights are being taken care of, your privacy right cannot be. So the age-old concept of civil and political rights versus socio-economic rights, one cannot privilege the other and one cannot trump the other. So it is not a judgment which has done a trade-off. It is a judgment which has tried to uphold the right to privacy, as also looking into, like Vrinda rightly said, the issue of dignity. And the reason Justice Sikri spent such a lot of time talking about dignity is because he talked about the basic rights. Large number of people in India, I don't have the exact figures right now, I was much better 4 months earlier when I was neck deep in the matter, but millions of people in India are still below poverty line, and therefore the court said that the basic dignity and the community value of dignity, to ensure that these people can lead their basic existence as a human being, is protected, and that is the goal of the Aadhaar project, because it's a step in ensuring that not only that the food subsidies and the other subsidies reach the correct person, it is also to ensure that it is not siphoned off by bogus people. So it wasn't just about the savings, it was also equally about the right of those individuals to be able to access the food. So it was the reason Justice Sikri formulated the problem in this manner was to ensure that people are not excluded. And this has also been considered in the majority judgment, that we have to look at I think Justice Bhushan deals with it, that we have to look at how many people were being excluded prior to the Aadhaar project as opposed to how many are being excluded now. So there are safeguards, etc., with regard to exclusion also provided, but these figures were really gone into. Secondly, there were large number of reports from the last 20-25 years that were placed before and the UIDAI had placed it as well as the union through the Attorney General, on how official reports as well as reports of independent public institutions showing state-wise data of how large number of bogus ration cards were found, in the tune of crores of bogus ration cards, which led to genuine beneficiaries being denied of their entitlements. And therefore a need was felt that the state should come up with a project which would ensure that the person who is at the food counter is the person who is the genuine beneficiary and entitled to the food subsidy or other subsidies. So therefore, keeping all of this in mind, the court has finally come to the conclusion that certain parts of the Aadhaar project has a legitimate state interest, and that was in fact, there is some debate on which is the right test to be adopted in the proportionality test, whether it will be a higher threshold of a compelling state interest or a legitimate state interest. And then Justice Sikri, finally speaking for the majority, says it will be the legitimate state interest if the act or the project seeks to further a legitimate state interest. Then we will come to the other aspects of proportionality. So moving ahead from the earlier Puttaswamy judgment, the majority did examine that the reasonable expectation of privacy has to be there first before we go into proportionality, etc., and so on and so forth. So it divided the data into two kinds: demographic data and biometric data. What was it being collected as far as the demographic data is concerned? Very basic things like your name, date of birth, age, sex, I think mother's name, and mobile phone number and email were optional. Now those were also being given because it would help in OTP authentication, etc. The court held that the minimal data was being collected. There was a prohibition under the act from collecting any kind of sensitive data like your medical records, like your caste, etc. And therefore it said that minimal data is being collected. There cannot be a reasonable expectation of privacy in something like your name when you're interacting with the world at large, asking the state to give you subsidies, etc. You cannot say that these kind of information is protected, is sensitive personal information. Then as far as the biometric data is concerned, the court satisfied itself, and we have to be conscious that this is writ proceedings we are talking about. The court does not have the capacity to go and launch an investigation. So it went by the material placed before the court and the processes that the government has used to enroll people, to authenticate people, etc., and satisfied itself on the basis of those. And therefore the PowerPoint was in fact very helpful, because what we did in the process was we completely lay bare and open to the court everything, to the extent without compromising any other security concerns as to going too deep into the architecture, and lay bare to the court, and the court gained enough confidence to come up with the judgment that it finally did. Beyond that, on your question on savings, I am not going to go too much into that, because beyond the point we didn't harp on that, because there were questions raised by the petitioners on the veracity of the data, etc. So what was done was we focused on the rights, because beyond the point, if privacy is being violated, savings can't really be a saving factor. As far as exclusions are concerned, there were several repeated strict circulars and office memorandum of the Cabinet Secretary, Food Ministry, UIDI, stating that no person shall be denied their basic entitlements like food subsidy, etc., merely because your fingerprint doesn't work, or if there is internet connectivity problem, you maintain an exception register. Now, on the ground, if there have been lapses, it is for those, I mean, there has to be a grievance redressal mechanism, there has to be a robust system which takes care of that. But we have to understand that it is not UIDAI which is the implementing agency. It is the state governments, and as far as the implementation of the National Food Security Act is concerned, that is a completely different issue altogether, and it's a serious issue. There are PILs in the Supreme Court pending of Swaraj Abhiyan. The court is also maintaining a continuing mandamus, trying to ensure they don't even have basic grievance redressal. So that is an issue that has to be taken care of in that direction and not here. And finally, as far as security is concerned, like I mean, it's an ongoing issue. It's something that even the UIDI presented, that we are continually improving our system. There are continuous patches being made, so that, because there are attempts to hack the UIDI server on a daily basis. So this is, and till date there has not been a single breach of the CIDR that we have maintained from day one. That CIDR and the biometric data contained in the CIDR, there has not been a single breach. That I don't think is even disputed by anybody. And finally, I would like to say that as far as Section 57 is concerned, it is a major success as far as the petitioners are concerned.
Right.
For the simple reason that one of the biggest fear, as Ms. Arora pointed out, was that there was a fear that in an Aadhaar world, your authentication logs will leave your digital footprints everywhere. And then UIDI, because these logs are created constantly in their central server, will be able to create a rich profile of you merely on the basis of where you go. Because we have to clearly understand that merely because you are giving your Aadhaar or seeding your Aadhaar with a bank account or with the income tax department, these data don't go to the UIDI server. These remain in the separate silos. So your bank account details do not go to the government. How much money you're keeping there, what mutual funds you have, all of that remain in the bank, with the bank. The government has other means to call for that information, the income tax department, ED, etc. if they want to. They don't need Aadhaar for that. They only need a simple notice under section 133(6) of the Income Tax Act, and the assessing officer will get all your bank account details. You don't need Aadhaar for that. Maybe they may want to launch a privacy challenge to that also. But Aadhaar, as far as it is concerned, was only to ensure that the person who is opening the bank account is the person who he claims to be. The person who has given the PAN number is the person who he claims to be. And I'll give a small example, if I am allowed some, I have some time, to why that policy initiative was done. I also happen to be an income tax lawyer, and I deal with a lot of these cases. Large number of accommodation entry providers, and it's a seriously large number. It's a complete industry. What happens is people create fake bank accounts, people create fake PAN cards, they create dummy directors, and they funnel their undisclosed income through these bank accounts and get loans or share capital back into their own companies and turn it into white money. So, and it is a regulatory menace. So, for that reason, so that it is a one PAN to one person, one bank account to one person, this policy initiative was done. And to a large extent, I mean, the PAN has had unintended consequences to the extent of 33,000 crores this year that we've been able to, I mean, those data may be up for grabs, but
the transaction value is 33,000.
That is the transaction value.
Right.
So those were the intended policy objectives. Now, as far as I'm coming back to the authentication logs, section 57, now having the private authentication having been struck down, the possibility of creating that rich profile is over as far as that is concerned. Nevertheless, the case presented by the petitioners was slightly futuristic, because none of that was happening today. There is no car which requires you to authenticate. There is no traffic signal which requires you to authenticate. There is so none of that. Secondly, we also pointed out that in all these 250 welfare schemes, you were required to authenticate once a year, except for maybe the food subsidy where you're going every month. So there was no concept of knowing what you're doing from morning till evening. Secondly, the authentication is required only at the time, was required, now it's been struck down, only at the time of opening of the bank account and not every transaction that you do. So therefore, there was no log being created. Again, I mean, there's so many things. Justice Sikri in his judgment also notes that in an airport, if assuming you have an authentication machine, people, the UIDI or anybody will not know where you're going, who you're traveling with, where you're coming from. It will only know that you have entered the airport. So,
And which airport?
and which airport you
So you
entered.
know where you boarded and where you exited.
Provided that
Only thing you don't know is the carrier which took me there.
The
That's
only-
all.
Yeah, so we
No
get to
such
that, aspect.
yeah, no such system
the
exists
tracking,
as of today.
Hope it a little more.
At the airport, what you show is your Aadhaar, physical Aadhaar card. You're not required to authenticate yourself as yet. So anyway, so these are the broad things, broad parameters. But the idea is to, really pin down ourselves to facts. We can go beyond any kind of emotion and passion, which is always great to ensure that we have a very healthy debate. But
Right.
the idea was to stick to facts so
Right.
that we can.
Right. So Orgo, I think the interesting point is the public versus private, which has been a constant, sort of refrain from the part of even the government of India, right? I mean, that Aadhaar, well, it is a limited, project. It's meant for certain few purposes, but the real villains are the Googles and the Facebooks. And the challenge has been constructing both tests which help you to figure out the limits of the state and engineering a model that helps you to protect your citizens against these private entities. And we all are now, at least after listening to all the three panelists before you, I mean, I think all of us agree that data is now increasingly central to whatever services, whoever provides it, the nature of the entity material to that exercise. So talking about a data driven world and business efficiencies particularly, and so many people I can hear today, fintech companies particularly, crying that, oh, Aadhaar is gone, how do we do eKYC, right? So there are huge benefits too from that aspect. I mean, 57, I'm not entirely sure whether it was the right move on the part of the state to strike it down under all circumstances. Perhaps consent could have been, a model, and which is what I think you are exploring when it comes to the personal data protection bill, right? To look at how much individual consent can be worked out and can be formulated and operationalized to build a regulatory structure for protecting personal data. So what do you think the Aadhaar verdict can offer when you are in that process of engineering? Does it have any great insights? And even going beyond Aadhaar, how do you think personal data ecosystem, protecting it from a regulatory and legal standpoint, is evolving in the country, and where are we headed there?
Yeah, thanks, Anand. There's a lot of points there, but to start with, I think that a 567-page opinion doesn't necessarily lend itself to certainty, because there's a lot there that all sides can use in order to make their own point. I realize the limitations that judges face and the rich material that is placed before it from both sides, whether it be text documents or PowerPoint presentations. But the fact of the matter is that I think that the Aadhaar judgment leaves a lot of open questions as far as where the digital economy is going. And I'm going to come to that in the second part. I'm just going to spend a couple of minutes, because once Zohaib has spoken about the facts, I'm not going to get into the facts of the Aadhaar question, but two central points. The first is that bad policy need not necessarily translate into an unconstitutional law. So we may have disagreements as far as whether a policy is implemented well, whether there are cases of exclusion, but ipso facto that doesn't make it an unconstitutional law. I think that's the first principle. The second is that a law can also not be struck down as unconstitutional on the basis of surmises and hypotheses. And a lot of points as in that were made are certainly possible. I'm not saying that they are not possible. I mean, we certainly could see a day if unchecked as an Aadhaar becomes a tool for surveillance, and we must guard against that. But today, to strike down Aadhaar on the basis of a potential future possibility is not an argument in constitutional law that I've heard of. Now, and that's where I think and Anant, you framed it well in terms of what does it mean to say that you're challenging the constitutional validity of the Aadhaar project, because it almost seemed like there were a lot of concerns with the project itself. As far as the court is concerned, the court can't really look at the project, it can look at the act and the regulatory framework that's been set up. And as far as the regulatory framework is concerned, things that can be said which are central to the Aadhaar project is the creation of the UIDAI, and there are a set of mundane provisions around those that exist, and a set of provisions around protection of personal information. That is how your privacy is going to be protected. Those may be good, those may be inadequate, but certainly those are the only provisions that exist insofar as protecting privacy in any statute in India is concerned. Now, beyond that, when we are coming to a court that's going to decide these issues, it's really going to decide on the basis of particular use cases. That is, whether it's valid for income tax, whether it's not valid for bank accounts, and so on and so forth. Now, here I think, and the important point to note is, we have to all ask ourselves two questions. The first is that what is the exact nature of the privacy right that's been violated? So, as Zoeb has said, that there could be three kinds of things over which my right to privacy might extend. One is my demographic information, my name, my address, and so on. I think we can all reasonably agree that being social animals, there's no right to privacy that exists in those. Second is my biometric information, where most certainly, as in there is a right to privacy that exists, but again, as with most rights, it's not an untrammeled right, and the court has found in this case that A, the collection of data is minimal, and B, and I think this is a critical point, as provocative as it may sound, that we don't have complete bodily integrity over our own bodies at all points of time. As in, if that were to be a principle that were to be accepted, then there couldn't be legally sanctioned bars on organ transplants, there couldn't be any bars on abortion. In fact, there couldn't be requirements to make use your thumbprint to attest any documents. So I think it's a principle that it disturbs me, but the fact is, I think we must recognize that the law sanctions all kinds of restrictions on bodily integrity of individuals. And the third could be with authentication records, which, as Zohaib has pointed out already, as in the possibility of a privacy violation of that, certainly has been taken into account by the court in section 57, whether rightly or wrongly. One quick point on proportionality before I get to the question about data protection. I think the issue with proportionality is as follows. The court has said that, as in has laid down this three-part test, that for any legislation to be valid, it must be backed by law. If it's a restriction of privacy, it must be backed by law. It must be necessary. It must be proportionate. And as far as proportionate is concerned, it has said that A, as in does it serve a legitimate objective? B, is the restriction rationally connected to that objective? And C, is it, well, they've actually said four things. Is it necessary for that objective? And B, even if it is necessary for the objective, when you balance it against the rights of the right holder, is it proportionate? As in, this is the way they formulated the test. I think the proportionality test, we should be clear here, provided an extremely useful device for the court to come to different factual conclusions as far as different use cases were concerned. So, if, as I was speaking to my mother who had read the judgment, who had not read the judgment, but it seemed to her that why is it allowed for income tax if it's not allowed for bank accounts? Either it should be allowed for both or not allowed for either. So, the fact is, it's a little difficult to understand sometimes as to what the distinctions in those cases are. And I think that that's why it's important to realize that proportionality provided a device for the court to come to different conclusions, and I think that's where the danger of proportionality lies, and this danger has been seen. There's a lot of literature in the UK. We can discuss that later. I'm not going to get into that now. But I think what it does, and I think a part of what was being said here, the discomfort with this PowerPoint presentation and so on, is because of the fact that when you're talking about a full-blown proportionality analysis, what you're essentially talking about is a very close scrutiny of costs, benefits, safeguards that are flowing from your particular program. And whenever you're talking about that, you're essentially talking about evidentiary questions. And you're talking about evidentiary questions in a court, in the Supreme Court, which is a court of judicial review. And so the fact is that the court, when it has set itself this standard of proportionality, which requires a very hard look into what's going on the ground, it needs data. And it needs data, and data is going to be supplied not necessarily by the lawyers, but by people who are the domain experts. And the traditional principles of judicial review, certainly on matters of policy and technical matters, involve a certain degree of deference to data that is provided by the government. Now, this principle may be questioned in today's age where we don't trust anything by anybody, but at this point of time, it's still good law. So, I think there's a danger here of proportionality, which sort of points to something that you'd written in the blurb for this session, which is that proportionality can be used to game the system, because if it's all about producing data, because in my view that's the only distinction that I could find between bank accounts and tax frauds, is that there was a lot of data put forward as far as tax frauds were concerned, that how many people had duplicate PAN cards and how much sort of it would have saved the exchequer if that were caught. And similar data was not provided for bank accounts, and similar data was not provided for cell phone usage. In fact, there was no data provided for cell phone usage, except to say that some terrorists use terrorists use SIM cards or some such thing like that. So the fact is that it's quite clear that if it is only about producing data, then the proportionality test is a double-edged sword, because it can and has, and we can go into examples, be used to game the system, as we can see it happening in the UK, as in that's the one I'm familiar with. It may have happened elsewhere. Lastly, it's simply uncertain and provides very little guidance in the way in which a court might go. As in, if the purpose of a Supreme Court verdict is some degree of authoritativeness, I think the proportionality standard detracts from that, because it's too subjective a standard. As we found, two judges found two different things on the basis of a proportionality analysis. So I think it doesn't provide good clear guidance to folks. But one can say that's the nature of law. So what is an optimal regulatory framework to prevent data breaches and privacy harms? I think the key point, and Ms. Arora made this point, and I think this is something that any right-thinking citizen is worried about, is the fact that you don't want to live in a surveillance society. But I think we must ask ourselves one question, as in, the moment we signed on to getting ourselves a smartphone and a Gmail account, somewhere we are all complicit in making sure that we have a society that privileges efficiency over privacy. Because we know, and the surveillance society, the Black Mirror-esque picture that was painted, isn't a dystopian picture in the future, one day when Aadhaar becomes efficient and can successfully breach silos. As in, if the government of India were this efficient in delivering subsidies, we wouldn't need Aadhaar in the first place. But the fact is that it isn't a dystopian future, it's here today. As in, Google knows today that I'm sitting here, Google knows that I have to go and take a flight in 5 hours time, and it will tell me that this is the amount of time that it takes to the airport, and show me a photo while it's at it. Okay, so the fact is that we know that this future is here today. Now the question is, that doesn't mean that we let the state off the hook. That's not my argument at all. But my argument is that when we think about what Aadhaar became, is that Aadhaar became the face of a legal challenge to a discomfort about a surveillance society. And I think when we think about that core issue about a surveillance society, we need to think about a data protection law that first treats all data controllers, whether it be the state or the private party, as data fiduciaries. This is what we've tried to do. I was a member of the Sri Krishna committee, and in our report we've tried to say that everyone is a data fiduciary. It owes a relationship of trust to the individual. Number two, the individual must be at the center of the data universe, which is essentially a requirement of informed consent. Much work needs to be done in terms of how informed consent can be operationalized. I'm not going to get into that. We can get into that in the discussion. And my last point is this, that if we were to think of a data universe where informed consent is the critical element and every data controller is a data fiduciary, then for Aadhaar, given that now the project has received the stamp of approval of the Supreme Court, the way forward in my view is clear. It's a limited mandatory usage, only when there is a weighty public interest involved that is necessary and proportionate, no matter how it's understood, but B, widespread voluntary usage of Aadhaar on the basis of informed consent of individuals. So if individuals want to use Aadhaar for a variety of purposes. They should be allowed to do so. If they don't want to use Aadhaar and want to identify themselves through some other means, they should absolutely be at liberty to do so. So I think that's where I think the future of Aadhaar might go. One last point, and I think this is something, this was a disagreement between Zohaib and Vrinda about the nature of rights, and I'm just going to leave with one point. I disagree with Zohaib. I think rights are always trade-offs, as in the nature of rights is such that it's always trade-offs. Trade-offs may be a slightly more pecuniary sounding word, but as in, if you're a constitutional lawyer, you'll just call it that it always needs to be balancing of rights, because the fact is that no right in the constitution is absolute. So whether it be the right to privacy or any other right, we are always looking at balancing between these two rights. So there's always trade-offs involved, and that's where necessity, proportionality and so on come in. Privacy is not superior in any way to liberty, dignity, equality, food or any other right in the constitution. So we always have to keep this interplay in mind.
Thankfully, the right against self-incrimination is an absolute right. So at the moment, nobody can get me to confess to a crime.
Where is your right of equality?
Right. Yeah. So with that, I think Vrinda, we'd like to just look back at this whole policy versus constitutional challenge, distinction that we all know is a pretty fluzy distinction in many ways, right? I mean, when the court wants to get into policy, it will say, okay, there's a question of principle involved. So drawing that line is pretty tough, honestly. I mean, maybe one way it could have been drawn better if the majority had held that there is a compelling state interest requirement rather than a legitimate one. So I'd like to hear your thoughts a little bit on why exclusion harms really took a beating, when the matter was heard before the bench.
So just before I answer, if I can just say 2 or 3 points to some of the things that were referred, and they may not be in order, but on the point Orgo made and sort of what you were talking about, and this is something that judges asked us again and again, right? If you have no problem with Facebook, what is the difference here? And I think a lot of people disagree on this, but just from my perspective. So obviously, one is that there is an idea of some element of consent and choice in signing up to these social media platforms. How much choice or consent there is, you could question it. But I think more than just that, there is an option on how much you want to engage with these platforms. So I may still be on Facebook, but a lot of private platforms have the option of, there are opt-out options. You can, shut off your location settings if you want on Google. If you choose not to use Google Maps, you can shut off location settings. So there is a way to engage with private actors. None of this is to say that private actors don't need to be regulated, but also an individual state relationship is just always qualitatively going to be different from an individual private relationship. And that is because the state at the end of the day has the power of law, has the power of violence and blackmail to use against you. And I think that is, what is the worst that Ola could do if for whatever reason, they can kick me out of the Ola platform. I would still have Uber as an option. And even though, you say Facebook really doesn't have an alternative, for people who really do care, there is DuckDuckGo, which is sort of this alternative social media platform. So I think there is a distinction when you say individual state versus individual private, and that comes to the role of the state. The second thing on, what you talked about, Section 57, and I know it's been one of the most contested aspects. I think it's worthwhile remembering Aadhaar was brought in as a money bill. And I think if the government took that decision for whatever reasons of bringing it in as a money bill, today you can't say, oh, look, it's too bad. There are certain costs to private actors. Well, you should have then brought it as a regular bill where it would have gone through debate. You can't have your cake and eat it too. And I just do not agree with Justice Sikri's argument that Section 57 is sort of incidental to, the Section 7 project. That Aadhaar is about Section 7 and Section 57 is sort of incidental. And I think, it's sort of what Zohaib also said, that the financial future of Aadhaar in some senses was coming from the 57. So I think it will be interesting to see what the government is going to do next, or, also how Aadhaar will move forward, or, will we see this kind of explosion still? The third thing, just, on voluntariness, I think it's also important to remember what is truly voluntary. So even when Aadhaar was voluntary in the context of passports and all, it was if you use Aadhaar, you'll get it immediately, but otherwise, you're going to wait for 10 days, and, in a Tatkal passport situation. So I think it's also important, even when we are having a debate of voluntariness, to talk about what is the meaning of voluntariness. And so just the last thing, and this brings me, it sort of ties in to your aspect of exclusion. I think when we talk about proportionality, so the heart is, as Orgo said, like what is the meaning of proportionality? So there has to be a law and a legitimate aim, I think is fairly certain. And I think Justice Sikri spends, it's interesting that he spends like pages and pages on legitimate aim, which, I mean, I think you can easily argue that Aadhaar has a legitimate aim. I don't think you could seriously contest that, you know, at its core. I mean, the extension is a different point, but at its core, you can say there's a legitimate aim. The third and the most important aspect of proportionality is necessity, and there was a lot of debate about what this test means. And the court agrees that this means that there must not be a less restrictive mechanism or a less effective mechanism to achieve a similar goal. And this para, incidentally, after spending pages on all the other discussion, Justice Sikri spends one paragraph on this necessity analysis. And I think regardless of what you say, of whether you agree, you know, coming to your question of policy or not, so what we were trying to argue was that there are alternatives. So, you know, you can use smart cards, even assuming the court wanted to go as far as to say local biometrics. The point is there are certain alternatives. Whether now you think that they match up is a question you have to examine. But to not even examine, and he just sort of in one line says that the petitioners did not seriously contest alternatives, is, according to me, just factually incorrect, because this was there in our written submissions. And then the last point is balancing, and that is where you sort of inevitably will have this slightly hazy thing about how you balance different rights. And I think this is where the exclusion figures come in. So our case was premised on two counts when we talk about figures. The government's entire case for Aadhaar was to say that we have all these thousands of crores of savings. So in PDS, I was just checking our written submissions, they said that, you know, there's 14,000 crores of savings because, you know, 2.33 ration cards have been found sort of ineligible. So that's, and that goes back to this whole idea of there being facts. So that was the government's main premise. And that was contested quite seriously. And I don't want to go into what the details of the factual contest was, but I mean, there was some contest on how the government arrived at these savings figures. We were also arguing that there are different kinds of fraud. So when we talk about PDS, you have three kinds of fraud was our argument. So you have, and this is something Justice Sikri doesn't even engage with. And I think my biggest problem with his judgment was that this lack of engagement. I think even if you had to hold it was policy or for any of these reasons, you should have engaged with these issues and said, you know, if that's what you want to say, that it's a question of policy. Justice Chandrachud does engage with it, right? And I think the fact that the majority doesn't engage with it, and just in this line, sort of in this para, says it's, you know, necessary doesn't really arise, and then on balancing cites and extracts the AG's arguments on savings. So our point was, you have three kinds of frauds in any PDS system. You have identity fraud, which is that Vrinda is claiming, you know, so X is claiming as Vrinda as well, or I'm claiming as someone else, which is something Aadhaar can potentially, arguably help in removing because of, you know, the deduplication and authentication. The second is eligibility fraud. So the fact that I am not a below poverty line person, or I'm not entitled to that particular subsidy, but because of whatever reasons, I have now got myself, you know, part of this list. You must remember, Aadhaar is not going to help in something like that. Aadhaar can only tell at its best, Aadhaar can only say if Vrinda is Vrinda. It can't say whether Vrinda is entitled to a PDS subsidy or not. And the third kind of fraud is quantity fraud. So that's, and you know, that goes again into what happens at the ground level, which is that if you're entitled to 25 kilos, I think is what it was, you know, rice under the National Food Security Act, the person will sign off as saying, yes, we are giving you 25, but they're actually only going to give you, say, 20 kilos. And that 5 kilos is siphoned off. These are three kinds of fraud. Aadhaar can help in arguably only in identity. It can't help in these two. Then there are also other issues of diversion that are happening before you're even coming there, which again Aadhaar cannot solve. So our argument was to say that it is not this 14,000 crore saving that you're doing. You will have to show us the burden is on, and the question I think goes on to who is the burden on in a case like this. And I think that's where legally it will have to, our case was, the burden was on the government to show that the majority of this fraud was by identity fraud. The court obviously didn't agree with us, and I know, I mean, Zoe also doesn't agree with our formulation, but our whole approach was to show that this is why exclusion has to be looked into, and this is why the savings figures have to be looked into. This on the then the question of exclusion and the fact that people are dying, that goes to the idea of Aadhaar being being a probabilistic, like biometrics being probabilistic. So we tried to to avoid this perception of just being policy, to bring it into a more legalistic analysis. Our argument was a probabilistic nature of identification will inevitably lead to exclusion, and you just cannot get away from that. And that is, and to that the state said, and as Zoe pointed out, that you have all these circulars and the AG's own assurance that no one will be denied benefits. The problem is, obviously, as you see on the ground level, is in a way, and this is again, we had affidavits for this, was that Aadhaar was increasing a different form of corruption. Because now all the power is concentrated again with the point of sale, the POS shop owner who can decide, do you or do you not have an authentication failure? Are you a genuine beneficiary or not? So there were affidavits that we had placed on record. Those affidavits don't actually find any mention. So I think for me what was sad is that there's no discussion of these affidavits. When you are relying, yes, proportionality is always going to be a very disputed questions of fact. The Supreme Court, and I think this argument would be okay if the Supreme Court traditionally did not go into these issues, but we do have a Supreme Court that's more than willing to go into facts when it wants to. I mean, this is a Supreme Court that has initiated PILs based on newspaper reports. But in all of our case today, they were like, oh, well, we can't really rely on newspaper reports that people are dying because of Aadhaar. So I think you also have to see the court's own consistency in how it's dealt with facts to be able to make that.
Only half a point.
Yeah, so that I think the reason
to be
I mean, I think the reason we feel so strongly is because we asked for cross-examination. That was not allowed.
Right.
We asked for our
Q&A.
yes, that Q&A does not answer. I mean, that Q&A. Now that Zoe brought it up, there was a question on authentication failure, and the government admitted they do not have details on state authentication failure. Right, so there's just no information.
But we don't know the location.
Yeah, so the point is you do not know how much is failing. The Economic Survey of India, the government's own report says there's 49% like authentication failure in Jharkhand, and there was 37% failure in Rajasthan. They also came up with this figure of 8.32% as iris failure, and I think some 6% for fingerprint failure, which was really never explained. Like, what is this 8.32%? How have you reached this? For the court to ignore all of this and then to say 99.78% is the figure that we are relying on, which comes from a previous 2010 document of the government, I think you either look at facts completely or you don't look at it. But I think the reason you speak to, I think, people from the petitioners, and the reason they're so exercised about this PowerPoint is because there was no cross-examination. We asked for it to be put on affidavit. The PowerPoint is not on affidavit, which, just in terms of very boring court practice, everything else was an affidavit and this wasn't. So I think this is something that really obviously bothered us. And Shyam Devan had actually said, we have people who've given affidavits. We are willing to fly them down to come and explain, sort of what we are seeing is the security problems with the project. And the court never really took us up on any of these options.
Authentic statement versus unauthentic statement.
So I think the broad point is that it also raises a lot of procedural challenges, right?
Yes.
When challenges of this kind are raised. But coming back to you, Ms. Arora, oddly enough, when listening to Zohaib, I felt, both from the perspective of the petitioners and the state, there is a vision of technology finally which goes to this whole story, right? There is a positive or a utopian vision that the technology will get better, it will evolve into something which reduces exclusion failures by and large as we proceed. And then there is also the dystopic vision that somewhere along the line this will end up being a surveillance project, neither of which honestly is at the moment the reality. So Ms. Arora, where do you think legally this whole dystopic vision is fits in, right? I mean, you mentioned some of the European cases and so on, but in the Indian constitutional law context, right? I mean, how much could judges have really sort of looked into this dystopic vision that is presented and say that, look, this is where it could head, and how much of the panopticon that you mentioned is constitutionally recognized in various different doctrines as you perceive it in India?
The first thing first, I think Vrinda did mention a fair bit on that. I'll just take it a little bit further from there, from what Arko had said just now. You know, uh, this is also to answer your question about how much of privacy intrusion constitution would permit and where is that line that you draw and how realistic is the digital intrusion into our lives or into our privacy. When I give away willingly or unwillingly my information to Google, Facebook, and the others, I may give it willingly on a consent or maybe unwillingly. I do expect the state there to stand by and then protect me when that information is misused. So the state is the parent patriarch so far as I am concerned. But when that state is going to turn into a person who's going to be a consumer of my information, then there is a very, very serious problem. If my protector turns into the very consumer of my information. So it is not a matter of just being fiduciary. The state is obliged to be fiduciary. It has no other option. But when it's going to be a consumer of my private information, I can fight against the Facebooks and the Googles, and I can expect my state to defend me then. Just like what Europe has done, just like what Germany has done, what Spain has done against Google and the others. The state stood up to this. But what when the state becomes a consumer of my own information? Then I do have a very serious problem there. Now coming to a point that how real is this issue of surveillance, the digital surveillance. You know, when I was getting into the matter and I was given this topic of surveillance, and I said, what the hell? I mean, I don't know much about technology. I'm one of the most technologically unsavvy person. So I requested some friends to come and talk to me who are experts in this particular field and educate me a little bit on it. And what came out from there was something that shocked me, and I said, we have to do something here. What my friends told me is, stop talking about surveillance or even about mass surveillance. You know, surveillance, what you're talking in terms of your ICAR, this is a thing of past. Today, the technology worldwide, and these are people who are in the field, mind you, who deal with the softwares, datas, imagery, everything. Surveillance is so technologically advanced with the use of satellites that if they had to do surveillance on me, they would do with the next 10 people around me 24/7, but of course that is expensive because that's individualized. And there's whatever that you can do with a person for the purpose of surveillance, including within your home. That much technology exists in the world today to do a surveillance through the walls. There was a illustration cited before the Supreme Court where in the US, through thermal imaging, the man who had been actually arrested and put into his house, the police even knew if he was in his shower or on his toilet through thermal imaging. So let's forget the fact that digital intrusion will not be there. There is a far superior intrusion which is possible, exists. Now let's come to the digital intrusion. Digital intrusion is not only basically intrusion into my privacy of my details, but what emerged before the Supreme Court and what ought to have been discussed by Justice Sikri, and although Justice Chandrachud notes on the state resident data hubs. Certain state resident data hubs had stored information which was far beyond even what Aadhaar required, which included their religion, which included their genders, which included everything. You know, the minute you start including religion, there is a serious problem. And these data hubs said that the information could be used by the other states for the purpose of convergence, etc. So where does this information about everything which gets into this domain lead to? You know my preferences, you know what I do. It's about mass control then, apart from surveillance. Because then you feed me information to the extent what you see my trends are. Why do you think on your Facebook, if you write today, you write Spain, tomorrow it will have 10 advertisements of flights heading towards Spain or destinations in Spain. How do they get that? So it is all possible with this, and when the data is to the extent it is, it's a huge intrusion into my privacy. That's where the Supreme Court in the judgment clearly said, I have a right of privacy. Now we test therefrom to where it can take us, and I'm sure that round is coming sooner than later.
Right.
Where we are going to touch that border is coming sooner than later.
So, Zorgo, quick response to the fact that the coercive power is what keeps the state separate from what you are engineering with the data protection bill, right? So, how do you, reconcile that, fact, right? I mean, the state can do a lot more to you than a Google or a Facebook.
Yeah, that fact is obviously true at this point of time, so that can't be contested. But I think if you were to throw some facts to make this problematic also, the combined market cap of Apple, Microsoft and Google put together is equal to or more than the last I checked the market capitalization of 119 countries put together. So maybe in India today we can say this, but I think we must realize, and this is a much larger question actually, because it has to do with the nature of constitutional law itself, is that it's ultimately about who can exercise power over you, and there's no doubt about the fact that the state can exercise. It has a monopoly over violence, and given the fact that this is a sort of constitutional framework that we've set up, this is going to be the case for some time to come. But I think we must realize that everyday actions of individuals are far more intrinsically interconnected with the private sector than it is with the state. Certainly, people here sitting in the room, I think that very rarely, unless we've jumped a traffic light or something of that kind, and if there's a policeman who happens to be around, the fact is, and well, many of us here are lawyers, so I'm not going to get there, but the fact is that our daily interactions are with the private sector. So the fact is that we are going into a situation where the private sector is going to increasingly play a more dominant role, and I think we must be cognizant of that, and that the choices that we make vis-a-vis, as in say a Google today, aren't really choices, number one. Number two is that when, certainly on the internet, most of this, and this is a valid point that Brinda was making about what do we mean by when we say something is voluntary. So, because on the internet that it's much easier logging into all kinds of third-party websites with your Google or your Facebook account than it is by setting up a new account. So the fact is that while it's voluntary usage of Google there or Facebook there, the fact is that it's really much easier. So I think the same kinds of arguments can be made equally between for all, and I do think we need to realize the fact that, and I think there is one last point on the state versus private, is that at the end of the day, the reason as to why Aadhaar has become the face of this legal challenge of privacy is because of the fact we must remember that the state is one that we can ultimately, flawed as it may be, hold fully accountable. The corporations sitting in Silicon Valley are not corporations that we can hold accountable in India today. They don't have a legal entity in India. They don't have a presence in India. They are absolutely unaccountable as far as Indian law is concerned. So I think we must realize that while the state does have this monopoly over violence, it also has the accountability. And one last point, as in about rights, as in I think I was misunderstood, and I'll make this point again. No right is absolute. Some restrictions may be stated in the right itself, like in Article 19. Some restrictions may flow out of the fact that two rights may need to be balanced in a given situation. So there could be several situations where you can obviously think of a right to equality going against a right to personal liberty. You can think of a situation where your right to self-incrimination, like a ticking time bomb kind of situation, is weighed up against somebody else's right to life. So the fact is that it's always subject to a balancing exercise. That's the point that I was trying to make, not that there are specific or whether the absence of specific restrictions in the text of the Constitution.
Right. So before I open up to Q&A, Zohaib, just a last point on what Brinda mentioned, right? The lack of engagement and granularity when it came to exclusion. Any last thoughts on, how you feel the court, in an ideal world proceeded, or what does it then bode, for a policy challenge in the future? I mean, does it mean the state gets away easier in many of these cases where ideally they should go into things in more granular fashion?
I mean, not necessarily, because uh, the fact that a policy could have addressed 5 problems and it addresses only 1 or 2 is a, in to put it in legal terms, is a problem of under inclusiveness, and under inclusiveness has never been a ground for striking down law, and that has been settled by constitution bench after constitution benches. So that strictly is what is being pointed out, is that okay, it addresses one of the kind of problems and not the other 2, cannot really be a ground to look at the constitutional validity of the law. So even if 10 lakh, 20 lakh, 30 lakh people were earlier excluded and now are being able to access their food or subsidies because of Aadhaar, is a good enough reason for the court to say yes, there is a legitimate state interest. So I per se do not agree with that
I'm not contesting
formulation.
legitimate state interest.
Yeah.
I'm contesting the application of proportionality.
Correct. So therefore, that is really an argument of under inclusiveness. That what it does is there are 3 kinds of problems that plagues the PDS system. Aadhaar only addresses one, and therefore we are in a situation that that one problem is not good enough to be addressed. These all go into the realm of policy, and therefore the court should have cannot step in and second guess the legislative wisdom in that sense.
Right.
Can I
So
add one word?
yeah,
there?
sure.
I only have one thing to say there, Sohaib. If that Aadhaar meets only one test as against 3 and will not address the issue whether the last man is getting in there his grain of food or not, then would you make something which can intrude into your privacy so seriously a tool to kind of meet with that, or would you not find alternative ways to deal with the same situation rather than to create a method or a tool which is hugely intrusive into your rights under 21? That's the only test that I
That
call for a
alternatives
question.
could have been.
Alternatives to that. That's
Right,
all.
and
In terms of-
scholars have been writing for a long time about that, Sunil Abraham and many others.